Bernie Sanders' tax proposal for the 99.5% Act has proposed several changes to transfer taxes and to various tax savings techniques. However, these changes will largely not be retroactive, despite a lot of the worry that's taken place in recent months about retroactive tax changes. However, there are some effective dates that vary based on the type of change, and transfers generally after those effective dates will be subject to the new laws if they are enacted. I'm Griffin Bridgers, and this is 10 Minutes with Griffin. For today's episode 178, we're continuing our discussion of the For the 99.5% Act. For this part 6, we're going to look at the effective dates for the proposed changes. Now, as always, this presentation is not intended to substitute for legal or tax advice and is provided for educational purposes only. And if you would like a copy of these slides, please email me at griffin.bridgers@gmail.com. On to the discussion. As you know, based on our last 5 episodes, we've been talking about the legislation introduced by Bernie Sanders titled For the 99.5% Act, which, while seems a long shot to be enacted, will create a lot of comprehensive changes to estate, gift, and generation skipping transfer tax laws. Now, even though there's no certainty here, we can at least see the tea leaves of what might be coming down the pike in terms of tax reform, especially this year, so you can plan for those types of changes. Now, one big question that's been on everybody's mind is that if I go ahead and act now, is there the risk that a tax law change will be retroactive so that any transfer I make right now will be no good? Now, even though there's a lot of anxiety around that bill, there is some certainty here in that the effective dates aren't going to be retroactive, except in one isolated case we're going to see. Instead, we're going to see really effective dates that are delayed until at least the time when this act becomes law. Now, starting off, the changes to the exclusion amount, the basic exclusion for gift and estate taxes, along with changes to the rates, will only be effective for transfers that occur after December 31 of 2021. So, starting in 2022, you'll have a lower gift tax exclusion, lower estate tax exclusion, and higher rates on transfers. But any transfers this year are still eligible for the $11.7 million applicable exclusion amount for both estate and gift tax purposes, and for generation skipping transfer tax purposes for that matter. Similarly, the increases in the maximum discount you can get with the special use valuation and conservation easements also only apply after December 31 of 2021. So these would kick in effectively on January 1 of 2022. Now, grantor trust changes are going to, 1, deny a step-up in basis for grantor trust assets not included in the gross estate, which is no, big change. That was something we suspected anyway. And they'll also cause inclusion of grantor trust assets in the gross estate, or a gift tax on the termination of grantor trust status. So, in terms of the effective date for these changes, it will be transfers that occur after the act becomes law. So, for any existing grantor trust, you're not going to see these new rules applying. Instead, you're only going to look to, 1, brand new grantor trusts that are created after the act becomes law, if this portion does indeed become law, and any assets transferred to an existing grantor trust after this act becomes law. Now, with that being said, one thing to keep in mind, too, is that this also applies to a beneficiary deemed owner trust, the BDOT or BDIT, or deemed inheritors trust. So this is also going to occur, or this is also going to apply if you have a trust that has a transaction after the effective date, which causes a beneficiary to be treated as grantor. So you can't get through this and only look to the grantor and terminate grantor trust status and then later on give a beneficiary a 678 power. Yesterday we talked about the reduction or loss of discounts for lack of control and lack of marketability. And those will only apply to transfers that occur after the act becomes law. In this case, anytime we're talking about a transfer, it would include transfers at death. So in other words, this would apply to decedents who die after the act becomes law. Similarly, for grats, we also have this same date of passage effective date. So any changes to the gift tax valuation on grats when they're formed will only apply to transfers to grats that occur after the act becomes law. Now keep in mind that we're not concerned about the decedent's death here because there's no change to the rules surrounding gross estate inclusion for grats. So the death of the decedent after the act becomes law is irrelevant with respect to grats. Now for GST exempt trusts, we have a 50-year limitation on the GST exemption, and at the end of that 50-year period, the inclusion ratio resets to 1 with a higher GST tax rate. Now for that 50-year period to start running, for one, on new trusts that are created after the act becomes law, it'll apply 50 years from the date of GST allocation to any new trust or any existing trust with a new GST allocation. However, for existing trusts, this is the one retroactive piece in this entire act. The 50 years starts running on the date that the act becomes law. So if you have any grandfather trusts or any trusts that are currently GST exempt due to previous allocation of GST exemption, the 50-year clock on those is going to start running when this act passes. Now, obviously, a lot can happen in 50 years, so who knows if this changes back or is updated in later legislation. Then finally, we have the changes to the annual exclusion, where we replace the present interest restriction on the annual exclusion with a new restriction that allows the annual exclusion for any transfer, but limits the donor to 2 times the annual exclusion for certain restricted transfers, such as transfers of interest in entities, transfers subject to crummy rights, so on and so forth. Now, this limitation and this change will apply only to calendar year gifts for years after the act becomes law. So in other words, if the act is passed in 2021, the first time this exclusion will apply is to calendar year gifts in 2022 and subsequent years. So in other words, this change to the annual exclusion has no relevance in 2021 if it is passed, and for 2021 you're still going to be able to rely on $15,000 per donee, but only for gifts of present interests. And that's it on the effective dates. As always, if you have questions or topic suggestions, you can email those to me at griffin.bridgers@gmail.com. Thank you for listening to this episode of 10 Minutes with Griffin, and I look forward to seeing you in the next one.